I'll be giving that away.
It's my wife. You're not me happy.
I don't get an introduction.
I'll give an introduction. How about that? Good morning. My name is Thomas Presley, and I am this year's chair of the Law Day Committee for the Shreveport Bar Association. I want to start by saying thank you to Dr. Peterson for allowing the Shreveport Bar Association to come and present to y'all today. Every year, the American Bar Association, the ABA, sets aside one day for annual Law Day. This year it's May 1st. So we, the Shreveport Bar, are taking the entire week of putting on events for different members of our community, mainly in schools, but on the college level, high school level, and elementary schools. The American Bar Association, in collaboration with local bars, puts this on throughout the country. It started in 1958. There was a collaboration between the Eisenhower administration and the American Bar Association. And we put on programs designed to help people understand how the law keeps us free and how our legal system strives to achieve justice. The theme every year is designed to spotlight one particular area, and this year's theme is the Magna Carta, a symbol of freedom under law. Of course, this is the 800th anniversary of the Magna Carta's signing and implementation in England. And Brian's going to tell you a little bit more about that, but I want to introduce our panelists, if you will, today. This is going to be a very interactive presentation. Like I said, I'm Thomas Presley. I'm an attorney at Cook Yancey here in Shreveport. I've been practicing since 2013, working for a federal judge here in town before beginning my private practice in litigation. We also have Bill Poinian. Mr. Poinian is an assistant United States attorney in the Western District of the United States for Louisiana, and he graduated from LSU Law Center in Baton Rouge in 1981, served as a county prosecutor in New Jersey, and began his career at the Shreveport office of the Western District of Louisiana's U.S. Attorney's Office. He's served as Assistant United States Attorney, First Assistant United States Attorney, and even Interim United States Attorney, and currently serves as counsel to the United States Attorney. He also teaches a class on constitutional law and national security at Northwestern State University. We also have Mr. Tom Arsenault. Tom is a 1972 graduate of LSUS and also graduated from Louisiana State University Law Center in Baton Rouge. He clerked for a United States District Court, went to a big law firm in Houston, and currently serves as a partner at Blanchard Walker, Quinn, and Roberts here in town, concentrating mainly on commercial law and state and local government law at Blanchard Walker. He also has served as a city council member for the city of Shreveport from 1982 to 1990, serving as its chairman. And finally, and most importantly, we have Brian Flanagan. Brian organized this entire event, and we are very grateful to him for doing so. He is a 2005 graduate of Berklee College of Music, a 2010 graduate of LSUS, a 2013 graduate of Louisiana State University Law Center in Baton Rouge. He currently serves on the board of directors for Catholic Charities and the Independence Bowl Foundation, and began his practice at Bronson Hall here in town, concentrating on civil litigation and appellate representation. And I'm going to turn it over to Brian. Thank you.
So before we start the discussion part, I just want to give a historical background of the Magna Carta. And the first question you might ask is, why was the Magna Carta written? And to answer that question, we go back 800 years to England, back to 1215. And King John is the King of England at this time. And there's King John. King John was very unpopular. He had a reputation for being cruel and petty and spiteful. He was unpredictable. He wasn't bound by any set of rules. Wasn't even bound by rational behavior. England was, he was fighting a couple of wars and they weren't going very well. And to fund those wars, he had imposed high taxes. And as you might imagine, that didn't go over very well. And so people had had enough, and England was on the brink of a civil war. And they all sat down with King John and tried to see if they could work out their differences. And out of those negotiations came the Magna Carta. Okay, this is what it looks like. This document was a set of rules that everyone agreed that they would follow, including the king. And at 1215, that was a pretty big deal, that the king agreed that he would be bound by these rules. You know, the king's power has limits. The king, can't just impose an arbitrary rule, but that he would be bound by the rule of law. And in effect, it has been said that this is England's first constitution. Okay, so we have a set of rules, but it didn't get off to a very good start. 10 weeks later, the Pope annulled the Magna Carta. Then the next year, King John died, and then the Civil War broke out anyway. So it was not a very promising start. But after that, King Henry III, who was King John's son, came into power, and he reinstated the Magna Carta. And the reinstated version was a shorter version. It was revised and it was condensed. And that was reissued in 1217 and then reissued again in 1225. And that was, 1225 version was what became English law. Now since then, almost all of it has been either repealed or superseded. Only 3 clauses are still in effect. So it's largely symbolic, with only 3 clauses still being in effect. It's important because it was an early example of a defense against the arbitrary rule of a king and a guarantee of individual liberties. And parts of it had a profound impact on the U.S. Constitution, specifically trial by jury, the right to travel, individual rights, and due process. And for this reason, the United States Supreme Court has cited the Magna Carta over 170 times in its decisions. Okay, 28% of those cases involve due process. Due process, as you know, is that a person can't be deprived of life, liberty, or property without due process of law. It's a very important principle in our Constitution. 13% were about trial by jury. 8% discussed how the Magna Carta influenced American constitutionalism. 6% were about antitrust matters and habeas corpus. 5% were about civil rights and liberties, and then 4% each were about cruel and unusual punishment and excessive fines. So what we're going to do is we took these principles, we took some cases where the Supreme Court has cited the Magna Carta, and we want to have a discussion about those cases. And for the first case, we have Thomas Presley back on.
I'm back. Sorry. Maybe 15 minutes. Okay, so our first case is about the right to travel, and whether this is a right that is guaranteed under the Constitution. So our first scenario is Kent wanted to travel to England to attend a conference. Mr. Kent was a well-known psychiatrist who wanted to travel for an international meeting. He had been alleged to have communist ties in the past, and of course, in the 50s, that was a big deal, McCarthy era and McCarthyism. But he, in 1926, the Congress enacted that you had to have a passport, which was a new idea, which seems strange to me. I would have thought that you would have needed it earlier. But in 1926, you had to have a passport in order to travel internationally. And in 1958, Congress furthered that. In 1952, Congress furthered the passport requirements and said that you always had to have a passport as opposed to just during wartime. So Congress passed an act that gave the Secretary of State the right to create rules and regulations in order to govern and establish rules for how to get a passport and what qualifications you needed to have a passport. So he was denied a passport because he was an alleged communist. And then he was denied on the basis of him needing to have an affidavit or a signed letter under oath saying that he was not a communist, or that he had been a communist in the past but was no longer an active communist. And he refused to provide any affidavit. The affidavit that was requested was very broad in scope. It wanted to know, it didn't have specific parameters on time. If he had been a communist in the last 2 years or 3 years, rather this was any time in his lifetime if he had been a communist. And he refused to sign that. And he argued that he had a constitutional right to travel. Does anybody know what his basis for that constitutional right of traveling was based on? Yeah?
Negative, but was that from 1926 to 1952 or 58?
52 was the second statute. So, and of course you still need a passport now, they just enhanced the regulations. So let's think about this. Constitutional law, right? You have the Bill of Rights, which give you certain personal liberties and personal rights. So the First Amendment, for example, gives you what? Freedom of speech, right? And press, exactly. The right to assemble. And what's he doing? He's going to England, Finland rather, for a conference, right? So conference is what? An assembly, exactly. So he's arguing that he had a First Amendment right to assemble and to have the speech that was going on at in the Finland conference. So what basis did he say? Was that his only argument for being able to go under the Constitution? Was that the only argument that he had? give you a hint, Brian mentioned this earlier.
Due process.
Due process, exactly. And the Fifth Amendment gives you the right to not have life, liberty, or property taken away. And so he argued that he had a constitutional right under the Fifth Amendment to not have, that he had a liberty, and that freedom of traveling was a liberty that he needed to have the right to be able to travel. So, does anybody have any idea how this got to the Supreme Court? I'll give you a hint. It was a Supreme Court case. Nobody knows the process of getting to the Supreme Court?
He killed it.
He appealed it, right? So he was denied, he lost the first one. He lost his first argument at the trial court level, at the district court level, and said, and the judge actually granted this on summary judgment, meaning that they never even had a trial, right? They said that that he had no right to travel, and that Congress had given power to the Secretary of State to create rules and regulations that govern the process of getting a passport. So he lost at the district court level. Does anybody know what happens next?
Appellate court.
The appellate court, right? So he was the district, or the Court of Appeals for the District of Columbia, and again, lost. And then what happened?
Appellate to the Supreme Court.
Right, you take a writ to the Supreme Court, and the writ was granted, which is very rare for a writ to be granted. It means that the court thinks that there's a very important issue that's at hand. And this actually was combined with another case where a author had also wanted to travel, also had communist ties, and was also trying to go internationally to expand his knowledge and know-how of different areas of the world. And so the court took it, and they said, yeah, let's listen to what arguments you have. And last night I actually got on a website that has all of the oral arguments from the Supreme Court. It's called OIA Project, exactly. OIA.org, I believe is what it is. And you can listen to the oral arguments. And the interesting fact in this case is, once the government got to the Supreme Court, they actually agreed that there was a constitutional right to travel under the Fifth Amendment, the Due Process Clause, under the Liberty statute of the Liberty portion of the Due Process Clause, the Fifth Amendment. And they said, you know what, we agree that there is a right to travel. But they didn't say that he should be allowed to travel in this case, and why not?
It's like a national security issue, or?
Right. So communism was a major threat to the United States at the time, and Congress had granted a certain authority to the Secretary of State, saying, please create some rules and regulations that allow for people to get passports, but they have to pass certain requirements in order to do so. But what happened? What do y'all think you would have a right to travel? Do you think the Supreme Court said, oh yeah, Secretary of State, please create these rules that inhibit travel but still allow for some travel, right? Or did they say, hey, passport's something that you need in order to travel, you have to have it now, and you should be allowed to have it? What are y'all's thoughts on that?
I'm really hoping the second one.
Right. They said mainly the second one, right? But there's still some very major issues that if you are looking at facing criminal crimes or criminal charges, for example, then the Secretary of State can say, no, your passports are revoked. You can't go travel because we're going to indict you. And so basically the bottom line is that you now have a constitutional right to travel based on the Kent versus Dulles case. Liberty is not to be deprived without due process of law, which means that you have to have some sort of formal hearing in order to have that. And actually, the Magna Carta was cited several times in this case and in other cases that deal with the right to travel, because the Magna Carta says you have a right to travel. And the Supreme Court agreed that it is a fundamental right, and it's something that goes back now 800 years, 732 years at the time. That's wrong, but that's okay, that's close enough. So there was a long history in Western legal tradition that you would have a right to travel, and it's very important. So that is case one, and I'm going to turn it over to Tom Marcineau for the second case.
All right, for the dinosaur in the room, now just hit enter, is that what I?
Yes.
Right arrow. This one? Yes. Okay, all right, everybody know what this is? Huh? Okay, now take out your cell phone, put it on silent, and then put it away, just like I did, okay? So you can't find this. Mine is an interesting case, and I know it is a tough deal to talk to a bunch of college students at 8:30 on a Monday morning, all right? So I just let you know that I am old enough that I had 7:30 a.m. classes at LSU in Baton Rouge on Saturday. That fortunately only for one semester. Then they decided attendance was more important than the rule of Saturday classes. But anyways, it's great to be here, and the Supreme Court cases are very interesting. So what I hope you will do is, as we go through these, there's no right or wrong answer. Dr. Peterson is not taking notes on your performance at this. So what I'd like you to do, feel free to just chime in. You don't have to be, there's no right or wrong answer. We're just having a discussion. So, feel free to pipe up as we go. The second case deals with the right to a trial by jury, okay? The Sixth Amendment of the U.S. Constitution guarantees a right to trial by jury. After we get through this, I'm going to read you the Sixth Amendment because this case is kind of interesting because of what it does with the Sixth Amendment. Mr. Duncan was accused of simple battery, okay? Now let me demonstrate this, well, but for consent, I want to demonstrate simple battery to you, okay? What is your name? Tamara? Okay, Tamara. I'm going to demonstrate battery. I'm not going to hit you. Okay? I'm going to demonstrate battery for you, but so that it actually won't be a battery, I would like your permission to do this. Do you trust me? Okay, well, I got my first victim of the day. Okay, so I have permission to do this, so. Okay, did you see what I did? We'll do it and I have permission again. Okay, now, that's a battery. If I don't have her consent, that's a battery. A simple battery is an unauthorized touching. Okay, so that's what a simple battery is, because it's kind of key to the facts of this case. So that's what Duncan was accused of doing. Actually, he and some buddies, Duncan is African American, and he and some buddies were, this is in the mid-1960s. Thomas's case a little earlier, what's 40s? 58. 58. Thomas's case in 58. Mine is decided in the late 1960s. So we're in the throes of the civil rights movement, and so what happens is there is a conflict between a group of African American young men and a group of Caucasian young men. And so Mr. Duncan gets accused of a simple battery. At the time, simple battery in Louisiana was punishable by a fine of a maximum of 2 years in the parish prison, or a fine of $300, or both. Okay. The key to the Louisiana position in the case is that Louisiana at that time defined a felony as a case that was punishable at hard labor. All right, that means you go to Angola. All right? If the crime was punishable by a crime in a parish jail or a city jail, then it was not a misdemeanor. All right, so that's how Louisiana differentiated between the two at that time, okay? So Mr. Duncan asked for a trial by jury, but because the case was a misdemeanor, Louisiana did not provide for a trial by jury for a misdemeanor. So Mr. Duncan was convicted, and the Supreme Court took up his case, as is the case in many instances in the Supreme Court. There may be several cases that are coming up at the same time that deal with the same issue. Sometimes that's how the court determines, hey, this must be an important issue. We've got a whole bunch of these coming up. And like Thomas's case, this case came up with another case similar, I believe, out of Illinois. So it was not uncommon for states at that time not to provide a trial by jury, okay? So the case kind of hinged upon whether or not this was a serious criminal offense, okay? One of the reasons that I've demonstrated on camera that's a battery, okay? So, is that a serious criminal offense? What I did to Tamara, is that a serious criminal offense?
No.
No, okay. So, do you think we ought to have a trial by jury for something as simple as that? I mean, think about it. How many of you have ever been called for jury duty? A handful, okay? And what's your name?
Joy.
Joy? Joy, what a great name for a Monday morning. When you were called for jury duty, kind of tell me what the process was. Was it here in Caddo Parish?
No, sir, it was in
In Bossier Parish. Okay, so tell me a little bit about the process.
It was rather long. We had to sit through, just to see and call our names, this is a presentation about what to do and what not to do. We actually didn't even have to sit through the court, because by the time we got up there, we were already.
All right, so but how much of your day was there taken?
We got there at 8, we left at around 2.
All right, and how many people were there?
It was about 30, maybe 45 people.
Okay, so for that day, right, 30 to 45 people gave up their day at work, right, or school or whatever it was, and they came down there. Now, is that something that we ought to be paying for? And inconveniencing all those people for something as simple as what I did to Tara? What do you think? Yeah? Why?
Due process.
Well, if I'm the accused, I'd like to have a trial by jury.
Okay, well, now let's look at another at another angle.
6 minutes.
Let's talk about juries, okay? Juries are lay people, right? And sometimes crimes, particularly the ones that Bill prosecutes, they can be extremely complicated, okay? So wouldn't we be better with someone learned in the law who can understand the facts a lot better than a jury? I mean, these are people who don't know anything about the law most of the time. Why would we want to make this, make people who are probably the least qualified be the people that make the decision?
6 minutes.
But why?
Because
Forget about the 6 minutes. I'm going to get to the 6 minutes, but why? Why would we do that?
Because it creates a fair trial. Whenever you have, the prosecution and your defense and pretty much a judge who has judged the law or knows the law and has applied the law so many times, you bring in those 6 people that might not understand the bill as good. It brings in an unbiased opinion of somebody that doesn't know either any of the parties involved, just what is being presented to them at that particular time. Okay. And a lot of it also could depend on the presentation of the facts by the prosecution and the defense to, make the decision go whichever way it goes.
Okay. Now, let me give you some further facts. Mr. Duncan, in fact, was sentenced to 60 days in the parish jail and $150 fine. Okay? Is that something that the Supreme Court ought to be dealing with? I mean, the guy was on, no harm, no foul, right? It was a simple deal, right? I don't see many faces agreeing with me. Okay. Duncan argued that he was entitled to trial by jury under the 6th and 14th Amendment of the Constitution. Okay, so Remember, this is the 1960s. Here's your easy test question. What do you think the court did?
They agree with them.
Who's that? All
I
right.
don't think that they agree with them.
You don't think they agreed with it? Okay, well, let's see. This is Duncan versus State of Louisiana. It's a 1968 case. And the court held that because the charge was punishable by a maximum of 2 years and a $300 fine, the defendant was entitled to a jury trial. All right, now here's some interesting things about this. First of all, I'm going to read you the Sixth Amendment. See, I'm a fancy lawyer. I don't carry it every day. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. Okay? In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. That's the Sixth Amendment. All right? Now, what part of all did the Supreme Court not understand? Okay? Because what the court said is, because it is a serious criminal offense, and they decided that the seriousness of the criminal offense depended on what the punishment was. And the result of Duncan versus Louisiana is that the court basically determined that if there were a penalty of more than 6 months, that had to be a jury trial. Louisiana now defines a misdemeanor as a crime punishable by more than 6 months. Okay, so things like a battery are now it's now a misdemeanor. So today, Mr. Duncan will still not be entitled to a jury trial, but he wouldn't be facing 2 years in jail. He'd probably still get the 60 days and $150. Okay, if he were convicted. There is some really good discussion in Duncan versus Louisiana about exactly the point that you raised. And the reason that Magna Carta dealt with a trial by jury is that, as you said, what's your name?
John Griffin.
All right, John. As John said, there is the folks in Magna Carta knew that everybody was kind of part of the system. The judge was appointed by the king. The lawyers were kind of all in the same club, right? So they thought that it was important, even though jurors were lay people, they thought it was important that there be a hedge against the government and the people that were part of the system to make an independent decision. And that really is what the basis for trial by jury is. Now, the technical reason, the Sixth Amendment is a prohibition against the federal government. Okay, the Bill of Rights, the original 10 amendments of the Constitution, the Bill of Rights, was not imposed on the states. What the court has done as a result of the Civil War and the constitutional amendments that came after that, the 14th Amendment also has an equal protection and due process clause. And so what the Supreme Court has done is they have applied certain of those rights under certain circumstances to the states through the 14th Amendment. And that was the basis for this decision as well. And there is a reference, if I can find it quickly, because I want to impose on Bill's time. The history of trial by jury in criminal cases has been frequently told. It is sufficient for present purposes to say that by the time our Constitution was written, jury trial in criminal cases had been in existence in England for several centuries and carried impressive credentials traced by many to Magna Carta. Its preservation and proper operation as a protection against arbitrary rule were among the major objectives of the revolutionary settlement, which was expressed in the Declaration and Bill of Rights in England in 1689. And there's some further history of Magna Carta in terms of how it actually kind of got into position. But that's Duncan versus Louisiana. Thank you very much for your attention. You get 2 Toms and two Flanagans, and that is, by the way, you may have noticed there's a resemblance there. They are, in fact, father and son. So I'll turn it over to Bill.
Thank you. Good morning. I guess I'm supposed to press the button or something?
The right arrow.
The right arrow.
Dinosaur helping dinosaur.
There you go.
You got it. There you go.
The first case we talked about was in the 1950s. The second case we talked about was in the 1960s. But we also want to talk about 2 more cases to show that these principles we're talking about will apply up to the present day and on into the future. And so I want to talk about 2 cases that have to do with what we'll generally call the war on terror, for lack of a better phrase. You can tell from the discussion we've had so far that some of the principle underlying the Magna Carta is really this tension between the crown and its subjects, or between the government and its citizens. You know, one of the complaints that the English had against King John, that stern-looking fellow whose picture you saw earlier, was that the king had the power, inherent power, by virtue of his sovereignty, that he could take any of his subjects and confine them, incarcerate them, for no reason at all, or for a very good reason. It could be you deserved it. It could be you committed a crime and deserved to be confined. And the king would exercise his power and send you off to the Tower of London. Or it may be that the king considered you a political adversary, or as a threat. Or maybe the king just didn't like you, and King John especially, who wasn't always acting rationally. He could just identify one of his subjects and send him to the tower with no more justification other than the king has ordered it. So one of the provisions in the Magna Carta was that no one would be incarcerated except by virtue of the phrase they used was by the law of the land. That you needed something more than just the king's say-so. So the law of the land, if you've heard that phrase before and used before, that's where it comes from. It comes from the text of the Magna Carta. And we call it today due process. That you cannot be deprived of life or liberty without due process of law. That you need something else other than the king or the executive saying this person that we have identified should be confined. So let me tell you about the story of Yasser Hamdi. Yasser Hamdi was 22 years old. He was captured in Afghanistan. In 2002, shortly after the war began in Afghanistan, he was captured by the Northern Alliance. The Northern Alliance, as you may remember, was a collection of different entities that were allied together against the Taliban. And when the war began, when the United States began the war, the Northern Alliance and the U.S. military were allies. So Mr. Hamdi was captured by the Northern Alliance. They turned him over to the U.S. military. The U.S. military sent him to, along with hundreds of others, to Guantanamo. He was interviewed once he got to Guantanamo. And the first couple of questions he was asked by his interrogators were basic questions. How old are you? And he said that he was 22. He was born in 1980. And then he was asked, where were you born? And he said, I was born in Baton Rouge, Louisiana. Now that stunned his interrogators. They thought he was from Saudi Arabia. And he said, no, I was born in Baton Rouge, Louisiana. I spent my early childhood in Baton Rouge, and I moved to Saudi Arabia with my family as a young boy. And the interrogators, it was easy enough to check out his story. And true enough, he was born in Baton Rouge, Louisiana. And by virtue of being born in the United States, Yasser Hamdi was a United States citizen. So they weren't sure what to do with Mr. Hamdi. So they took him from Guantanamo and they sent him to a Navy brig in Norfolk, Virginia. Eventually they held him in South Carolina. And he was designated by virtue of having been captured in Afghanistan, designated as an enemy combatant. So, what does it mean to be an enemy combatant? An enemy combatant is a designation given to you by virtue of the executive branch of government looking at the circumstances of your capture or what you did. And you're designated as someone who has taken up arms against the United States. And by virtue of that designation, you get sent to Guantanamo. So, Hamdi was, and it's the executive branch, but it's not the president who actually sits down and makes these determinations. It's an advisor to the Undersecretary of Defense, and et cetera, et cetera. But nevertheless, he was designated as an enemy combatant. Even though he's a U.S. citizen, he's now in a Navy brig in Norfolk, Virginia. And Hamdi says, well, am I going to be charged with anything? And the government says to him, no, you're an enemy combatant. He says, well, do I have a trial? The government says, no, you're an enemy combatant. Hamdi says, how long will you hold me? The government says, indefinitely, until we say you can go. Does that mean potentially my entire life? The government says yes, if that's what we determine it needs to be. So, does anyone see any problem with the government now? And granted, there are hundreds of foreign fighters detained in Guantanamo Bay under the same circumstances as enemy combatants. But Hamdi is a U.S. citizen. He's in a Navy brig in Norfolk, Virginia. And the government says you will stay here for as long as we say, because we have designated you as an enemy combatant. Does anyone see any problem with that?
U.S. citizen has the right to his words.
Yeah.
I think he was first U.S. citizen and then enemy combatant, so he has the right of due process.
Well, he filed a lawsuit. Hamdi files a lawsuit. And in the lawsuit he says exactly what you have said. Because Hamdi says, I'm not an enemy combatant. Hamdi says, I'm an aid worker. I wasn't taking up arms against the U.S. I was there in the wrong place at the wrong time, but I was there as an aid worker to help the injured. The government says, oh, no, you weren't. We have information, we believe you took up arms against the U.S. So Hamdi files a lawsuit and says, I deserve to have some way to challenge my detention. Can the government, can the executive, can the king point to someone and say, for whatever reason, justified or not, because we designate you in a certain classification, we send you to the tower. We send you to the brig in Norfolk, Virginia. Or does Hamdi, as a U.S. citizen, have a right to contest that somewhere? That's the case that went to the Supreme Court. What the Supreme Court said was, what the Magna Carta said, that you can be confined only based on the law of the land. What the U.S. Constitution says, you cannot be deprived of your liberty without due process. That he deserves some due process. The government's argument was, well, he got some due process because in the process of designating him as an enemy combatant, there's some review levels, and there's a process we follow before that designation is given, and that's the opportunity to contest whether or not he actually is an enemy combatant. Hamdi says, I was not part of that process. I had no input to that process. But, nevertheless, even if I did, it's the government that makes that decision. It's not due process unless it's a neutral fact finder, a neutral body, that is, in our case, a court, who can determine whether or not I'm an enemy combatant or not. So what the court said, what the Supreme Court said, was the Constitution requires that Hamdi receive due process, that he has the right to be some due process. The government could charge him with treason. That would be fine, because then he would have a trial. And that trial would be due process. But if you're not going to charge him with treason, there has to be some way in which he is apprised of what it is that he did, told what he did, what the allegations against him are, and given some opportunity before a neutral body to decide whether or not he actually is an enemy combatant. So the postscript to Mr. Hamby was, after the Supreme Court ruled he has to have this hearing, is that the government simply released him. Sent him home. They stripped him of his U.S. citizenship, put him on a plane, and sent him back to Saudi Arabia. So the court guaranteed that he would get due process in some way, and the government's options at that point were, well, we can give him this hearing and have a court determine whether he actually is an enemy combatant, or we have to release him. And the government decided to release him, sent him home to Saudi Arabia. That was Yasser Hamdi. There's another one, and this isn't actually a case because it didn't get to the Supreme Court, but we'll mention a fellow named Anwar al-Awlaki. Anwar al-Awlaki was a U.S. citizen. He was born in New Mexico. He went to school at Colorado State. He studied engineering. He also did graduate work in San Diego. And he later moved to Yemen. The U.S. government, based on a lot of intelligence, identified al-Awlaki as an operational leader of al-Qaeda. He was involved in he had a lot of contact with the 9/11 hijackers before 9/11. He was involved in the underwear bomber on the plane from Nigeria to Detroit on Christmas Day. He was identified as being involved in a lot of terrorist attacks. So the government, the executive branch of government, the president, ordered the CIA to find, track, and kill Anwar al-Awlaki in Yemen. So the president, and with the advice of a lot of defense and national security experts, all acting as judge, jury, and executioner, could identify a U.S. citizen and say, we will assassinate that U.S. citizen, with nothing more than the designation or the approval of the president, of the king placing one of its subjects in the tower, of the president identifying an individual for assassination. I didn't see a problem with that. It happened. In September 2011, al-Awlaki was killed by a Predator drone strike in Yemen. His father filed a lawsuit after the fact for wrongful death, blaming the U.S. government for an unlawful and unconstitutional exercise of its power in identifying his son, a U.S. citizen, to be assassinated. The government's argument was this was a military operation, but there was no war in Yemen at the time. Al-Awlaki's father's argument was there's no due process, that if you just have the executive act as judge, jury, and executioner, where is the due process guarantee that you won't be deprived of your life, that a U.S. citizen won't be deprived of their life without due process of law? Where is the there's no due process. At the district court level, as Thomas mentioned early on, the case begins at the district court level and then goes from there to the Court of Appeals, Supreme Court. At the district court level, the judge at the hearing was very troubled by it. There was no due process. I'm not even sure what due process could be given as a practical matter at that point. Or, do you have to go to a court to get a court to approve it? This is uncharted territory. The the underlying principles are the same, but it's applied over and over in new circumstances that couldn't even be imagined 20 years ago. But nevertheless, the district court held that dismissed al-Awlaki's father's lawsuit and said As troubled as the district court was by the whole practice, the court said this is a military operation that the courts really cannot get involved in. It just would not be practical for the courts to be, if the military is going to carry out a mission, that somehow come to the courts first to be passed on. So the court dismissed it. Al-Awlaki's father did not appeal. He just dropped it at that point. So we don't know how the Supreme Court would have handled that case. But it's still, to this day, a troubling issue, a debatable issue, about whether or not, in the context of the war on terror, can the United States president, whoever the president happens to be, identify a U.S. citizen and order that they be assassinated, without any further review from that. Okay, the fourth case and the last case we want to talk about. Oh, this is the rest of Hamby. Have to give meaningful opportunity to contest the factual basis, etc. Okay, case number 4 is a case of the Supreme Court named Boumediene versus Bush. Boumediene was not a U.S. citizen. Boumediene was from Bosnia, actually. He was arrested in Bosnia by Bosnian authorities. They thought he was involved in a plot to blow up the U.S. embassy in Sarajevo. The Bosnian authorities looked at the evidence and they didn't feel comfortable in going forward with it, but they turned him over to the U.S. military. The U.S. military sent him to Guantanamo Bay. He and a lot of other people at Guantanamo Bay were being held there. And by this point, the government realized there has to, for all these people we're holding in Guantanamo Bay, there has to be a, what are we going to do with all these people? I mean, we can't, even if we exerted that we had the power to hold them indefinitely, as a practical matter, we just can't hold them the next 50, 60, 70 years. So they come up with the idea of military commissions. And that's a whole separate subject about the military commissions and the whole history of the commissions and who had the power to do what. But suffice it to say, the military commission process was not going very well. It was going very slow. It was a brand new process, and there were a lot of, it was just taking a long time. So Boumediene and a lot of others similarly situated to him filed a lawsuit, filed for a writ of habeas corpus. We haven't really talked a lot about habeas corpus, but the writ of habeas corpus is sort of an offshoot of the Magna Carta. The Magna Carta doesn't talk about habeas corpus. It talks about the law of the land. But there had to be some way, which the king agrees to be bound by the law of the land. There had to be some way, some procedural vehicle. How do we get this? Who's going to hear these cases? And what is the law of the land? And about 100 years after the Magna Carta, England passed the habeas corpus statute. Habeas corpus in Latin literally means you will produce the body. And what it is a procedural vehicle by which a person who's being confined can challenge the confinement. It files for a writ of habeas corpus. If the court grants it, he is brought to the court, and whoever is holding him has to justify the confinement. So that's a simple explanation. We have the writ of habeas corpus in the U.S. It's in our Constitution. It's in the suspension clause. It's in the Constitution in a curious way. It's not an affirmative grant of power. It just says that the writ of habeas corpus shall not be suspended unless, except in cases of insurrection, rebellion, invasion. That's why it's called a suspension clause. But Boumediene, they filed for writ of habeas corpus. And they say, the military, and the government says, no. We're learning from this. We have military commissions now. And they're going to have their right of due process in the military commission. And when Congress set up the military commissions, in order to stop all these pesky lawsuits, they also said that we will set up, Congress, they set up these military commissions, and that's how the prisoners will have their cases heard. And by the way, no federal court any longer has jurisdiction to hear a writ of habeas corpus application from any of these prisoners. So Boumediene and the others, they filed for writ of habeas corpus. Government says, no, you do that. Congress said you cannot file for writ of habeas corpus. The court has no jurisdiction. What goes to the Supreme Court is the issue of whether Congress meant to suspend the writ of habeas corpus. It can do it in cases of invasion or rebellion. And it's been done by Congress only 2 or 3 times in our history. So the issue went to the court and said, did the Congress intend to suspend the writ of habeas corpus? And if they intended it, was it valid? The court said, well, yes, they did intend to do it, because this is what it says. But it's not valid. It's not a valid suspension, because it can only be suspended in terms of, in the case of rebellion or invasion. And in neither case, in this situation, was there rebellion or invasion. Therefore, it's an invalid suspension of the writ. And Boumediene and the other prisoners can have their cases started. So, this is when Congress established a military commission, it had the power to deny their access to courts. And the court said no. That's an invalid suspension of the writ of habeas corpus, which flows from the due process clause, which flows from the Magna Carta. And they are entitled to have a hearing in federal court, in addition to these military commissions. Postscript to Boumediene was released. He never had a military hearing. He didn't have a habeas corpus hearing. The government by this point was trying to close Guantanamo and was looking at different people they could repatriate home to their countries without any further proceedings. So Boumediene wound up going back to Bosnia. So the point is, through all these, through the underlying tension which began 800 years ago between the crown and its subjects, and exists today between the government and its citizens, the exercise of power. And that's what the Magna Carta, by requiring the king to abide by the law of the land, addressed. It's what the due process clause in our Constitution addresses. It's what the Supreme Court has applied in cases about the right to trial, and the right to a jury, and the right to hearings, and the right to habeas corpus. So what happened 800 years ago is still relevant today, and is still applicable today, and is the foundation for many of the cases that come before the Supreme Court, that have come before the Supreme Court, and will continue to come before the Supreme Court. So I think we're about 5 minutes left. So if anyone has any questions for any of us, or any other, what?
I was president of the Shreveport Bar Association.
Oh, Ben Pulley's. Yeah, 5 minutes.
I drove up in the parking lot here, and Tom made a comment, well, I hope we don't get a ticket for parking, because that's what happened when I was here back in the 70s. They said Tom graduated from LSU in 1972. That can't be possible, because in 1972 I was here, and it was not a 4-year institution. I was here from 72 to 74, and they had our 3rd year in 74.
I did matriculate here, though.
Yes. I noticed when I left here that it was a lot tougher here than it was down in Baton Rouge at times. I want to thank y'all for coming today. This has been a wonderful exercise. Thomas Presley, who is the chairman of the law, we don't have law days. Law day is actually on Friday. We have law week here, and this is the first of the presentations during law week. We had to start with the discerning group, because tomorrow we have to go to the elementary kids, and they're really a tough group. We're dealing with the 5th graders, and you know that show, it's you smarter than a 5th grader. I think you find that you're not smarter than a 5th grader when you deal with the 5th grader. But on behalf of the Shreveport Bar Association, we want to thank you for allowing us to come here and talk with you. I wish you a pleasant week. And if you have an opportunity to come to any other law day functions for the Bar Association, we're looking forward. We have things going on all day. Thank you very much.
Huh?
You press the button, you go. Yeah, you got it. Okay, my students who are here, be sure you sign this on your way out, please.